Good afternoon, everybody. Welcome to our Wednesday webinar. We here at Bracket Long are offering a series of fortnightly webinars on a range of different subjects for individuals, families and businesses. My name is Reggie Lloyd. I'm an employment solicitor and I specialise in employment law. And I'm joined by my colleague, Brianna Billington, who is a trainee and who is going to qualify as a solicitor in December. And she'll be joining the team in December, and she's going to sit in on this and she may answer a couple of questions later on. This week's topic is fire and rehire, and I've chosen that topic because it's something that's been used by the media fairly recently, and as you probably know, it describes a situation where an employer wants to change terms and conditions of employment, and fire and rehire has certainly been used by the media to describe the tactics used by employers if they want to change terms and conditions. I'm going to deal with a slightly wider topic today, not just fire and hire, but other options that are open to employers if they are considering changing terms and conditions. And what I propose to do is to just run through the slides fairly quickly, and then we can take some questions at the end. And next slide, please. We all know that since COVID arrived that things have changed, and certainly people have not been working under the same type of arrangements that they were working under in, say, February, March 2020. And because of that, a lot of employers have been considering what to do now that we're coming to the end of COVID, and some surveys have been undertaking, and they've asked employers what their proposals are now that we seem to be coming to the end of COVID, and now that furlough is going to end at the end of September. So you can see from the slide that I've got on the screen that in one survey, it said that 33% of employers expected their employees to return to work normally into the office on a full-time basis. 28% said that they will offer their employees the option of working 3 days per week, either at home or in the office. 14% have said that they will allow their employees to work fully flexibly, so it'll let the employees choose the days that they come into the office or work from home. In a separate survey, 68% of employers said that they were considering pay cuts, location allowance, London waiting, and as you can see on the left of the slide, there was a matter published by an unnamed government minister who had said that people who are not going to work should be paid less. And the reasoning behind his suggestion was that if the employee is now no longer incurring commuting costs, then the wages should be reduced. Next slide, please. So as things seem to stand at the moment, and as we seem to get back to normal, a lot of employers will be asking themselves, what are they going to do? And it seems from the survey that at least some employers are thinking that they're going to have to change contractual arrangements. And it certainly is likely that employees who were employed before the lockdown in March 2020 will probably be working on different terms and conditions in September 2021. So the purpose, as I say, of this webinar is to consider what are the options if the employer wants to formalise those arrangements or change contractual terms and conditions. So we start with the contractual principles. Once a contract is formed, it's binding on both parties. It can only be amended in accordance with its terms or by the agreement of both parties. Next slide, please. So you have some options to proceed if you want to try and change terms and conditions of employment. And the first option is to seek the agreement of the employees. And if the employees don't agree, then dismiss those who don't agree. You can terminate the existing contracts and issue new contracts, which is the fire and hire issue. Or you could impose the changes unilaterally and then leave it to the employees to make the next move, decide what to do. And as I said, fire and hire is in the spotlight, and you've probably seen the publicity that British Airways and British Gas got when they said that they were going to impose unilateral changes. The government has looked at this and they've commissioned an ACAS study, but the government has taken a very neutral stance on this matter, and they said at the moment they don't intend to legislate to prevent employers firing and rehiring. Next slide, please. So if you decide that you're going to impose changes, you will have to first look at the contract. Hopefully the contract is in writing, because that's going to make it easier to ascertain what the terms of the contract are. And you can have a look at to see if there are any specific flexibility clauses or other mobility clauses. For example, in a contract of employment, it's not unusual to have clauses saying that the employee will work at a particular location, but within a reasonable area. It also has to work in a reasonable area that the employer requires. For example, working in Essex or working in East Anglia. You can also have a clause that says that the employee will work flexible hours, although his core hours might be 9 to 5. The clause may say something like they will work additional hours as the business requires, and won't get any extra pay for that. The third type of clause that you usually get is a mobility clause, and in certain contracts you will get a specific mobility clause which will allow the employer to move the employee to a different location. For example, it could say that the employer is entitled to move the employee to another office in the UK, perhaps Manchester, and it will spell out in that clause how much notice the employee has got to be given, and who's going to incur the costs of the relocation. Because if somebody moves, they'll have to perhaps sell a house, they'll have to transport their belongings to the new location, so you can get a very specific mobility clause in the contract. The not so good news, I suppose, for employers is that any sort of a flexibility clause in a contract will be given a restrictive interpretation. And also, if the employer tries to utilize a flexibility or a mobility clause, the employee can also try to rely on a breach of the implied term of trust and confidence. Next slide, please. So we can have those general flexibility clauses that they allow the employer to make the changes to the terms, but these are rarely enforced by tribunals because it does evade that contractual principle that changes to a contract must be mutually agreed. Only the clearest language may give the employer some chance, and I'd set out a couple of examples there. In that Bainham Phillips case, there was a clause at the end of the contract which basically allowed or purported to allow the employer to vary the contract from time to time, and of course it was held in that case that that wasn't sufficient. The Bateman and Asda case, which you may have come across, was extensively reported in the press, and in that case there was extensive consultation by Asda, and unfortunately it hadn't been pleaded very well, the case, and it hadn't been alleged that the employees were worse off. I think there were 6 test cases, and in only one of the cases was it suggested that the employee was worse off. So the EAT held that there was no breach of the implied term in that particular case. So it does, at least it does muddy the waters to show that in certain circumstances that the employer may be able to impose contractual changes. Next slide, please. This is a Court of Appeal case in Wandsworth, and that was quoted extensively in the Asda case. And in that case, the Court of Appeal made it clear that if there is a clause in the contract that the employer wishes to rely on to vary the terms of the contract, the language used must be very, very clear. But it then went on to say that if the change could produce an unreasonable result, then the court should seek to avoid that. So it's a bit of an uphill struggle. Next slide, please. I mentioned the implied term of mutual trust and confidence just a couple of moments ago, and this is something that the employee can rely on when they're seeking the employer to rely on a flexibility or a mobility clause. The issue, of course, is that the imposition of the change amounts to a fundamental breach of contract, and therefore it breaches the implied term and entitles the employee to resign and claim constructive dismissal. And in the BPCC and Webb case, you can see that there was a clause there in the contract which allowed the employee to be moved to a different department, but when they did move him, his wages reduced. So the tribunal found that that was a breach of the implied term because of the reduction in wages. However, if there's little or no loss of earnings, then there may not be a breach of the implied term. So if the loss of earnings had been minimal, but I suppose what you've got to keep in mind is that even if there isn't a breach of the implied term, if wages are reduced, there could be a claim made for unlawful deduction from wages. Next slide, please. So what are the options for an employer if he wants to seek changes to the terms and conditions of employment? Well, probably the best way is to seek the employee's express agreement to the new terms by consultation. And what you will have to consider if you are considering changing terms and conditions from the outset is how many employees are going to be affected by the change and whether there is likely to be any dismissals because of this reorganization restructure. Because if there are, well, then the collective consultation rules may kick in. So you'll need to at the outset establish how many people are going to be affected by this, and then decide on whether it's collective or individual consultation. So the first option is to seek the agreement. The second option is to unilaterally impose the changes. So if the changes were minor, perhaps a good example is if the employees started at 9 o'clock in the morning and you wanted to ask them to come in a little bit earlier, say at 8:30, and finish a half an hour early, you could decide to try and impose that change and see would the employee accept that. Because if the employee doesn't protest and doesn't resign, well then you may be able to argue that they have impliedly agreed to those changes. The third option is the fire and rehire. So you simply just terminate the old contract and offer new terms, or in some circumstances you might just be terminating the old contract and not offering new terms. There may be a redundancy situation. Next slide, please. So just going back to that option 2 of imposing the change, what amounts to implied agreement? So this will be a situation where you impose the change on the employee, and if the employee continues in employment rather than resigning, well then you may be able to argue that he has impliedly accepted the change. So as I say in the slide, if the contractual change has an immediate practical impact, such as wages, duties or location, and he continues to work despite that change, well then you might have a better chance of arguing that he has impliedly agreed to the change, or if there's a breach of contract, that he has acquiesced to the breach. If the situation is that you're trying to change, say, restrictive covenants or something, for example, restrictive covenants won't kick in until the employee leaves. So if you imposed a new restrictive covenant and the employee did nothing about that, well then it's less likely that the court or the tribunal would accept that the employee had accepted that change, because there's no immediate practical impact on the employee. Next slide, please. So what are the employee's options if a unilateral change is imposed? So as I said, the employee could acquiesce to the breach and carry on working. and hopefully you'll be able to argue that he has impliedly accepted the term. He could work under protest by raising a grievance or just raising a complaint in an email or raising a complaint orally. But just because he works under protest, if there was a deduction in wages, he could make a deduction of wages claim, and that would signify that he wasn't happy with the wages that have been that's change in his wages. If there's a fundamental breach of contract, he could resign and claim constructive dismissal, or the employee could just simply refuse to work under the new terms, and then that causes an issue, because the question is then if he's refusing to work under the new terms, is he disobeying a lawful order? For example, the example I gave earlier was if you asked him to come in a half an hour earlier and he says no, can you discipline him? Because he will say, well, it's not a term of my contract that I started 8:30 in the morning. My contract says that I start at 9, so that will present a bit of a problem if the employee just simply decides not to work the new terms. There's an old case that some people may have come across, which is Hogg and Dover College. And in that case, there was a radical change to the employee's contract, and then he was given a new contract, and he successfully argued that by the termination of the old contract that he had been unfairly dismissed. So there is a possibility that employees may be able to run their argument, but it's only run on in very specific circumstances. The employee could also resign because of an anticipatory breach of contract. So if an employer makes it very clear that, for example, in 2 weeks' time, their wages is going to be reduced by 50%, well, then the employee can resign at the time that they're told that that's going to happen, because it's a breach that's going to happen in the future, and the employee doesn't have to wait until the breach actually occurs. They can resign straight away. But as I say, if there's any delay in the resignation, well, then the delay might be considered to be affirmation of the new contract. Next slide, please. So if you get to the stage that you have to dismiss somebody, or get to the stage where somebody claims constructive dismissal, then the way that you will be defending the claim is probably on the grounds of some other substantial reason. So don't forget that when it comes to a dismissal, the tribunal will apply a two-stage test. It will first of all establish whether the employer had a fair reason for the dismissal. And usually in these types of cases, the reason put forward by the employer is some of the substantial reason which could justify dismissal. And then if the tribunal is satisfied that it was some of the substantial reason, then they'll go on to decide whether or not the dismissal itself was fair in all the circumstances. And as I say, it's reasonless fair procedure. So to get over the first hurdle, the employer must demonstrate that it had a sound good business reason for the changes. The change does not have to be for the survival of the business. There was an old case called Catamaran Cruisers, where it was made very, very clear that the employer doesn't have to show that the business is going to become bankrupt before it imposes changes to the employee's wages. But the reason mustn't be a trivial, arbitrary, or capricious. There's always a temptation when a tribunal looks at these types of cases that the tribunal thinks, well, what would I have done in those circumstances? So there's been lots of case law that says that the tribunal must not substitute its view. And the test that the employment tribunal must apply is, was the sound business reason one which a reasonable employer would consider sound? So it's that objective test. Would a reasonable employer have wanted to make these changes? Next slide, please. So on balance, I think the easiest part of the unfair dismissal claim to defend is, of course, the reason. As long as the employer can provide cogent evidence to show that there was a business need to change the terms and conditions, they will probably get over the first hurdle. But the second aspect of it, the fairness of the dismissal, is really, really difficult. And it entails a balancing act by the tribunal. Because what you will have is competing interests. the employer on one hand will want to make changes to make sure that the business operates efficiently. But for example, if it's imposing a reduction in wages, well, then the employee will obviously say, well, I've got a mortgage, I've got bills to pay, and if you reduce my wages or I accept those changes, it's going to fundamentally affect my standard of living. So there can be an irreconcilable conflict between the employer and the employee, and that is what the tribunal has got to try and sort out. Next slide, please. So when it comes to that issue of fairness, these are some of the factors that the Employment Tribunal will take into consideration. So the more of these boxes that the employer can tick, the better chance they have of persuading the Employment Tribunal that the dismissal was fair. So we will look at the employer's motives for implementing the change. Although this is the second part of the test, they will look at the general, the reason why the employer implemented the change. And then, of course, the employee's reasons for rejecting those. Whether the employee was given reasonable warning of the proposed change. So the longer the consultation period, the better. Was the effect of the changes fully explained to the employee? So again, the consultation process is very, very important, that the employee fully understands the effects of the changes on the business. Did the employer assess the impact of the changes on the employee and consider the alternatives? Did the employer attempt to get the employee to agree the changes? And did a reasonable, genuine consultation take place? And another factor is whether the majority of other employees accepted the change, because I suppose it could be argued that if most of the employees have accepted the change and only one or two employees haven't accepted those, that these are just difficult employees, and it may then help the employer in succeeding in that argument of reasonableness. And finally, if it's a large employer, were the trade unions involved, and what do they say about the changes? Do they agree or object to the changes? And next slide, please. So back to the fire and rehire. If you do decide that that's the way to go forward, give notice to terminate the old contract, because if you give notice, then there won't be a breach of contract. At the same time, then you offer the new terms. It's often been asked whether or not, if the employer terminates the old contract and the new contract terms are slightly different, say for example, as far as wages are concerned. So let me give you an example. If the wages are going to reduce by, say, £100 per month, can the employer then argue that because the employee did not accept the new terms, that if he wins his unfair dismissal claim, that his loss should be limited to £100 a month? And the answer to that is probably not. But as you can see in the Belcher case, that the EAT there felt that the tribunal had come to the correct decision when it said that it wasn't just inequitable to make a compensatory award, because the new terms of the contract were not any less favourable. So it does mean that in certain circumstances you may be able to run some sort of an argument as far as mitigation is concerned. Next slide, please. So in summary, the first thing that you need to consider is, do you need to make the contractual changes? What's the benefit if you make the changes? What's the financial benefit going to be? Are they minor or are they significant? If they're just minor changes, you could just impose them and wait and see. If there are major changes, well, then you'll probably have to inform, consult, and seek agreement with as many people as possible, and divide and conquer. So you will find out how many employees object to the new terms, and then you may need to single those out and then have further consultation meetings with those to see if you can persuade them to agree the terms. And if they're not agreed, well, then you may try to compromise and change the terms slightly so that they will agree to them, or if not, then you can offer settlement agreements to those who don't agree. Ultimately, you can dismiss those who refuse and argue some of the substantial reason, but of course, with any litigation, you'll have to think about the potential costs, and you often will have to weigh up what the cost savings are to, if the changes are implemented, and whether they outweigh the risks or the costs of any tribunal claims and any awards that may be made. So next slide, please. Okay, before we take up any questions, we'll be sending out a recording of this webinar, and I think that's going to go out tomorrow. And we'd also include a link to a very short survey, and we'd really appreciate that if you could just complete that so that we can make sure that our future webinars are helpful to you. As I said at the start, this is just one of our series of Wednesday webinars, and our next Wednesday webinar is the pitfalls of COVID-related fraud, and that's being run on the 15th of September. So if you're interested in that or any of our future webinars, please visit our website or go to our Eventbrite page to sign up. Now we'll take any questions.
Hi Reggie, we've got one question that's come in. Question from Anonymous, where the employer has changed employees' normal location of work without issuing a contractual change, yet still requires them to remove their previous commuting miles home to original contractual place of work from any mileage claims. Is this reasonable?
Sorry, can you just, I mean, it's a very long question, so can you put it on the screen so I can see it, or?
Yeah, you should be able to see it from the. Oh yes,
Q&A.
So where the employer has changed the employee's normal location of work without issuing a contractual change, yet still requires them to remove their previous commuting miles home to original contractual place of work from any mileage claims. Is this reasonable?
I'm not really sure what the question is. I mean, I suppose if the employee has moved location and is working at the new location, I think the answer to the question is that they probably have acquiesced, to if there was any breach of contract, they've acquiesced or they've impliedly accepted the new location. I mean, as far as the mileage is concerned, I suppose it depends on what the arrangement is. Is the question that are they still entitled to that mileage? Sorry, Sarah, is that what the question is? Are they still entitled to claim the mileage allowance, or?
Yeah, I think it's obviously they claim a mileage for their work commuting, obviously, but they've changed their place of work. So are they home to original?
Oh, I see. Yeah, I mean, generally speaking, mileage is not able to be claimed from commuting from your home to your place of work. So that would be unusual. It's only when you go from your place of work to visit a client. But if the employee is home-based, which it doesn't seem that this employee is, well, then it is unusual that the employee will be entitled to claim a mileage allowance.
Thank you, Reggie.
I mean, if I haven't answered that question, I'm quite happy if the person wants to ping me an email, so I can fully understand it, and then I can reply to that.
Great, thank you, Reggie. Next question is, could you explain a little more about the divide and conquer approach?
Yeah, I think when it comes to trying to impose these changes, it is about consultation and really trying to persuade the employees, that that they should opt for the changes. I mean, it's going to be very, very difficult to do it, if there aren't very good business reasons, but if there are good business reasons and perhaps there's going to be threats of redundancies and things like that, it is about sitting down and explaining to the employees, what's likely to happen if these changes can't be agreed. And you find that most employees are fairly reasonable, that if they do think that the changes are necessary and there is a potential risk, I suppose, of them losing their job, well, then they may agree to the changes. And of course, there's nothing wrong with employers introducing temporary changes to say, well, let's do this for a period of time and let's wait until business starts coming back through the door and then we'll go back to our old terms and conditions. So it often is about getting a group of people on board that are going to agree, to those changes, to accept those changes. So if you have, 15 employees and 10 employees say, yes, we're going to agree to those changes, well, then you've got to then put a little bit more time and effort into the other 5 employees. So what I would suggest is you get the first 10 employees to agree and get them to sign the new contracts, and then you move on to the next 5 employees. And then you may have to, offer different terms, or you may have to offer a bonus, or you may have to offer some incentive for them to agree to those changes. And then hopefully you might get 1 or 2 of those to agree to the changes, and they might be slightly different to the 10 other employees, but at least then you've got the changes that you want. And then if you're only left with 1 or 2 employees, then you've got that reasonableness argument to say, well, all your colleagues have accepted the changes, and therefore, if this gets to an employment tribunal, that's something that we will be raising when it comes to fairness. And then, you've only got 2 employees, so you reduce the exposure to risk. You could use compromise agreements or settlement agreements and pay them off, or you could then take the chance and only have 2 employment tribunal claims. So, it's that piece by piece approach, and I think that's always a good way to approach it. And your tactics will change as you move forward. You may be more likely to compromise with the 5 employees who haven't initially agreed and give their terms and conditions, give them better terms and conditions, but at least then you get there and you achieve what you sought to achieve without, and minimizing the risk of claims being made in the tribunal.
Thank you, Reggie. Next question is, can we mandate employees, if they are on a 20-hour contract, to work overtime on a regular basis? Our contract says in certain circumstances it may be necessary or reasonably to adjust or exceed their normal working hours to meet requirements of their job.
Yeah, I mean, that really goes back to the interpretation of those flexibility clauses. I mean, it's got to be reasonable. I mean, I know that's a terrible word to use, but that's what the courts will say. So, I mean, if you ask the employee occasionally to work overtime, that's going to be okay. But if you're going to ask the employee to work a lot of overtime every day, every week for a long period of time, well, then that's probably not going to be reasonable. And going back to those flexibility clauses, it's likely that the court or tribunal will give it a very strict interpretation. So it's one of degree, I'm afraid. It's a bit like, it's a bit like a mobility clause where the employer says, well, look, we can require you to move location. If the office moves a mile, well, then it's probably not going to be too unreasonable to ask the employee to travel an extra mile a day. But if he's got to travel an extra 50 miles a day, well, then it's not going to be that easy to impose that kind of a change, even though the clause says, well, we can get you to work in East Anglia or whatever it is. So it's about that issue of reasonableness. Hope I answered that. Okay.
Thank you, Reggie. Next question is, what qualifies as a reasonable consultation? Do all meetings have to be documented, or can you have had informal discussions?
I mean, my view, and from being in the tribunal, is that you should document everything. Because even if it's an informal discussion, just make a note after the meeting or just a quick note at the meeting, just so that you can show that, that you did have that conversation, and just write down the gist of what is said. because it really is very helpful when you get to a tribunal. And as I say, when I gave you the examples of, what will the tribunal take into consideration when they're considering the fairness of the dismissal, and one of the issues is the consultation. How long was the employee told about these proposed changes? And if you can go back and say, well, if we had an informal meeting 6 months ago, and you just have a little note of that to show that it occurred, well, then you're in a much better position. So the answer is yes. I mean, my view is yes. Although it is tedious, do make the notes, even if they're brief notes, do make notes, because when it comes to a tribunal, it'll be 2 years down the line, perhaps, before you get to the tribunal. And it's very easy for the employee to say, oh, I don't remember that. But if you've got a note, well, then it just supports the case.
Thank you, Reggie. Next question is, where an employer has asked a manager to alter hours worked to include cover on occasional Saturday mornings. This will not alter total hours, as other time can be taken off. Would this be considered a minor change? The business reason is that hours of the department have changed and the manager cover is required to keep up with this.
Well, I suppose the first question is there that flexibility clause in the contract? Does the contract say you're required to work additional hours? And then it comes down to that issue of reasonableness. And I mean, just because the employer would want the employee to work on a Saturday morning, you'd have to take into consideration the reasons if the employee refused. Because if he said, well, I'm sorry, I look after my daughter, my young child, because my mother or my wife works on Saturday, well, and that's going to be an issue that's going to come into play. But I suppose the starting point would be to have a look at the contract, see if there's that flexibility clause in there, and then you then have to assess whether or not it is reasonable. I mean, the best thing to do is to try and come to some agreement with the employee and work out if there's a way that you can both agree the hours that he works and the Saturdays that he works, because if he agrees to it, then he's much more likely to do his job to the best of his ability, rather than if he's working and he's unhappy about it.
Thank you, Reggie. Next question is, if an employee is continuously having weekends off and has been doing so for the last 6 months, where the employment contract is silent on days off, does this mean it has become an implied contractual term through custom and practice?
Well, I suppose it's, I don't know. I mean, it's a very unusual thing for employees, not to be challenged as to why they didn't attend work. I mean, so it suggests that there seems to be some flexibility in the days that the employee works. But normally speaking, if an employee doesn't turn up on a Monday and they're supposed to be there on a Monday, somebody from HR is going to have a chat with them and say, well, where were you, and why weren't you in yesterday? And if it's sickness or holiday or there was some reason, well then. But I mean, it's a kind of a dangerous situation if the employer hasn't challenged them, because I suppose the employee will argue, well, I wasn't obliged to come in on that particular day, and that's supported by the fact that my employer never challenged me about it. So it may be a bit of a problem. And practically, I suppose you probably need to call the employee in and have a chat and get something defined as to what their days and hours are. Thank
you, Reggie. Next question is, when fire and rehire is implemented and employees' contracts are terminated and they are issued with new contracts, I presume their continuous service entitlements remain in place. Could you confirm this, please? Yeah,
that would be right. Yes, because there has to be a break in continuity, and in these circumstances there won't be a break in continuity. As people probably know, the break in continuity has got to be at least a week, and that week has got to be from a Saturday to a Sunday. So you've got to be very careful about that. It's not just, it can't be from a Wednesday to a Wednesday. That won't break continuity. But in a fire and rehire situation where there is no break in continuity, then their continuous employment will remain the same.
Thank you. Next question is, If it is not addressed in the contract or handbook and flexible overtime is worked, is holiday accrued on those hours worked?
I think the answer to that is yes. I mean, there's been fairly recent cases on overtime, and in my view, we get lots and lots and lots of complaints about holiday pay, and that's one thing that employees really hold very dear. You know, that they do get paid holiday pay, and in my view, I mean, I would always encourage employers, you know, to make sure that the employee is not in any way feels aggrieved about not getting the correct holiday pay. But my view is that if it's overtime, well, then it certainly has to be taken into consideration when it comes to holiday pay.
Great, thank you. And the last question is from Wendy. If the employer dismisses an employee who refuses to accept the new terms, you state it would be under SOSR. Yes. How would the employer explain the actual reason for dismissal?
Yeah, well, you as I say, what you have to do is to show that there was a sound, good business reason for you imposing the changes. So, as I said, you're going to have cogent evidence to you know, to show the employment tribunal that it wasn't just a whim. You just didn't decide we're going to change everybody's terms and conditions. There was a restructure or reorganization required. And then you get over that first hurdle and you prove that it's you know, it is for some other substantial reason. And then you've got to then deal with the fairness of it and explain to the tribunal, you know, why there were no alternatives besides dismissal.
Great, thank you, Reggie. One question has just come through while you were answering that question. When employing someone with epilepsy, what should the employer do?
Well, I mean, it's a different subject altogether. But I mean, if somebody, you know, it has somebody working for them who is suffering from a disability, well, then you will need to assess, you know, what reasonable adjustments have got to be made, and it may well be that you need a medical report to establish, you know, what the parameters are. But that's a different subject, I'm afraid.
Thank you, Reggie. That's all the questions that we have for today.
Okay. I mean, all I can just say, and just recapping, is, I mean, you know, try the approach of, you know, speaking to employees and getting their agreement. And if you can get the agreement, well, then that's the best way forward. If not, well, then you may have to take a bit of a chance and take your chances in the employment tribunal if you decide to dismiss or fire and rehire or whatever. As I say, if any of the questions, I haven't really answered any of the questions correctly, I'm quite happy for you just to ping me an email, and either myself or Rihanna will get back to you and give you a more definite answer. So again, thank you very much, and we hope to see you again shortly.